When do you know that your rights have been violated? How do you know that your rights have been violated? It's difficult to tell if a debt collector or a telemarketer is calling from an ATDS. Why is it sometimes difficult to tell? Because sometimes it's a human voice. People come to me and say, companies will come to me and say, well, we don't use a robo-dialer, so we're in the clear, or we don't have a robo-voice, so we're in the clear. That's not true. It's not the type of voice that defines the violation, it's the type of machine or software used to make the call. So if a machine or computer screen has the capability to dial 2,000 calls in a day, whereas somebody dialing on a rotary phone would not have that capability, that's a violative machine if you don't have the adequate consent or had a revocation of consent. Now, as a consumer, you will be tipped off by the number of calls. If you're getting called twice a day by the same company for a month, you could probably assume that they're using some kind of machine or software that has the capability to dial thousands of calls per day. I don't think, and this is me speculating, that a person with a list and a rotary phone is going to go through their list once, come back to the top of the list by the end of the day, and then start again and call you twice or 3 times per day. If you get a call once a month and it's a person talking on the phone, you might not have an ATDS situation. You can also tell if it's an ATDS or a robocall if it is a robocall. If you hear, hello, my name is, and it's a robot, or a pre-recorded voice on a voicemail, you know it's a robocall or a pre-recorded voice. I know that sounds silly. As soon as that happens, after you've either revoked consent, or if you know for a fact you have no contractual privity with a corporation, privity meaning you're in contract, and they call you, you know your rights have been violated. From that first call, you're entitled to damages. What are those damages? $500 per call, up to $1,500 for willful wanton. What do? You come to an attorney. The attorney will say, okay, here's a piece of paper with various itemizations that you need to do to prove when the calls were made, who made the calls, the company, et cetera, and you will then be able to file a lawsuit on your behalf. Lawsuits are usually filed in federal court. It's a federal statute, and it proceeds like a normal lawsuit. How long does a TCPA case take? Almost every one of my clients, plaintiff or defense, in any subject matter that I represent them in, asks me how long their lawsuit's going to take. Unfortunately, the judicial system is an imperfect system, and sometimes it gets backed up. The good thing about the TCPA is it's normally in federal court, and in federal court you have the best of the best judges. You can't mess around. We really have to dot our I's and cross our T's and make sure the case is progressing at an adequate pace. The judges also do a very good job of making sure the cases move at an adequate pace. That said, cases can take a year, cases can take 2 years, depending on the complexity and the size of the matter, if it's on an individual basis or a class basis, and the number of documents, defendants, and plaintiffs that you have. Other factors include the judge, the time of year, and how many cases that judge may have on his docket. It's pretty common knowledge that most cases today, in the upper 90%, don't actually go to trial, but are settled before the trial stage. And these cases are what's called ripe for summary judgment, meaning the issues are factual issues. The legal issues or there's not many factual issues, I should say. The legal issues are something that can be determined by a judge before the case is reached, before the case gets to a jury. So I know I didn't answer how long exactly they could take, but I would say it ranges anywhere from 4 months to a year and a half, 2 years.